Well, you know, when all is said and done, there's really no way to predict, because in a case of this magnitude, the court reacts to the emotional and political overtones of the issue. And certainly the state challengers and the private challengers have done their best to raise the emotional tone of these arguments. In the state brief on minimum coverage, I finally decided that we should have a drinking game, because I began counting each time the word unprecedented was used in their brief, and the total was 19 times in you know, about 80 pages. The idea being that there's danger here, something terribly dangerous is going on, and the private party briefs go further. They basically try to say that the Congress is inherently corrupt, that this process cannot be allowed to stand because Congress basically designed it to be politically palatable to the country, and they go on to predict that we will be, you know, really will be forced to eat broccoli and you know, we'll be forced to buy American cars, that we're going to live in a kind of Big Brother dystopia if this minimum coverage provision is allowed to stand. The government's interest has been much more to kind of say, you know, calm down, nothing to see. This is just the way policy is made. And it will be very interesting to see how the justices, particularly the ones who have not, cannot absolutely clearly be nailed to a position going in, it's going to be very interesting to watch the emotional tone of their questions. Because I think that will matter as much as the quality of the briefs or anything else. It depends on your definition of conservative. I think that if you take seriously the Scalia branch of conservatism, which claims that the major function of the judiciary is to defer to the democratic process, except when some express prohibition within the Constitution is crossed, then the conservative reaction would be to say, fair enough, this may be this may be a stupid law, but the process enacted in the political process can deal with it. I think the economic theory that's floating around, and the question that we're all waiting to get some hints about, is whether this court is actually going to go from that judicial restraint conservatism, which was born in the 80s, into a new economic libertarianism. And the private party's brief in particular puts before the court an argument that I call the Lochner was a wimp argument, where they basically say, look, you know, look at these insurance contracts that the Congress wants healthy people to enter into. They're suboptimal. They're disadvantageous, not actuarially sound. They constitute rents because you're making young people buy insurance that they may not need, and that under economic theory that means they're paying more than they should have to. Well, if the court goes down that road, as I say, we're in for something like the Lochner era, or potentially in for something like the Lochner era, but on steroids, because the invitation from both of the parties challenging the Affordable Care Act is basically, Congress is illegitimate. We need the court to police every aspect of the process from now on. If I were a justice, I wouldn't want to get into that, but you know, I'm not.
Professor Epps, I appreciate your taking the time to talk with us about this.
It's my pleasure, anytime.
Thank you so much.